Is the preamble a part of the Constitution? Whether the preamble is a part of the Constitution has been an important constitutional question in India. This issue has been clarified through decisions of the Supreme Court. Early view, not a part. In the Berubari Union case, 1960, the Supreme Court held that the preamble is not a part of the Constitution. The court stated that the preamble only explains the objectives of the Constitution and is not enforceable in a court of law. Later view, part of the Constitution. This view was changed in the historic case of Kesavananda Bharati v. State of Kerala, 1973. The Supreme Court held that the preamble is a part of the Constitution. It reflects the basic structure and philosophy of the Constitution. Though it is not enforceable, it can be used to interpret constitutional provisions. The court also held that while the preamble can be amended, its basic features such as justice, liberty, equality, and secularism cannot be destroyed. Present position. The present legal position is that the preamble is a part of the Constitution. It is not enforceable by itself. It plays a vital role in constitutional interpretation. Conclusion. In conclusion, the preamble is an integral part of the Constitution of India. It acts as the guiding spirit and foundation of the Constitution and helps courts understand the intention of the Constitution makers. Yes. The Supreme Court has held that the preamble is part of the Constitution. It is not enforceable by itself, but it has great interpretative value. Is the preamble amendable? The question whether the preamble can be amended has been an important issue in Indian constitutional law. This has been settled by judicial decisions of the Supreme Court. Early view, not amendable. In the Berubari Union case, 1960, the Supreme Court held that the preamble is not a part of the Constitution. Therefore, it was of the opinion that the preamble could not be amended under Article 368. Changed view, amendable. This view was overruled in the landmark case of Kesavananda Bharati v. State of Kerala, 1973. The Supreme Court held that the preamble is a part of the Constitution. It can be amended under Article 368. However, the amendment must not destroy the basic structure of the Constitution. The court clarified that features like justice, liberty, equality, secularism, democracy, and sovereignty form part of the basic structure, and these cannot be altered or removed. 42nd Constitutional Amendment. Using this power, Parliament amended the preamble through the 42nd Constitutional Amendment Act, 1976, by adding the words socialist, secular, and integrity. Present legal position. The present position is that the preamble is amendable. Amendment is possible only under Article 368. The basic structure cannot be damaged or destroyed. Conclusion. In conclusion, the preamble of the Constitution of India can be amended, but only to the extent that its basic structure remains intact. It acts as both a source of power and a limitation on Parliament's amending authority. Yes. The preamble can be amended under Article 368, but the basic structure of the Constitution cannot be destroyed. Amendments must respect core values like democracy, secularism, and justice. Role of the preamble in constitutional interpretation. Courts use the preamble to understand the spirit of the Constitution, resolve ambiguities, protect fundamental values. It acts as a moral compass for governance and judicial decisions. The preamble plays a very important role in the interpretation of the Constitution of India. Though it is not enforceable by itself, it acts as a guiding light to understand the meaning and purpose of constitutional provisions. Key to the mind of the Constitution makers. Preamble reflects the intent, philosophy, and ideals of the Constitution makers. When the meaning of any article is unclear, courts look at the preamble to understand the true spirit behind it. Aid in resolving ambiguity. If the language of a constitutional provision is ambiguous or unclear, The preamble is used as an interpretative tool to give a meaning that supports the objectives of justice, liberty, equality, and fraternity. Guide to the nature of the state. Preamble declares India to be a sovereign, socialist, secular, democratic republic. Courts rely on these values while interpreting laws to ensure they are consistent with the constitutional character of the state. Judicial recognition. In the Kesavananda Bharati v. State of Kerala, 1973, the Supreme Court held that the preamble is a part of the Constitution and forms the basic structure. Therefore, constitutional interpretation must protect and promote its ideals. Earlier, in the Berubari Union case, the court recognized that although the preamble is not enforceable, it helps in understanding the scope and purpose of constitutional provisions. Limitation on amendment power. The preamble also acts as a limiting factor on Parliament's power to amend the Constitution. Any interpretation or amendment that damages its basic values is not allowed. Conclusion. In conclusion, the preamble acts as the sole and guiding principle of the Constitution. It helps courts interpret the Constitution in a way that upholds democracy, secularism, justice, equality, and national unity, making it an essential tool in constitutional interpretation. Criticism of the preamble. Although the preamble is an important part of the Constitution, it has faced some criticisms from scholars and critics. The main criticisms are as follows. Not enforceable by courts. The preamble does not provide any legal rights or duties. A person cannot go to court directly for enforcement of the preamble, which limits its practical use. Broad and introductory. Terms like justice, liberty, equality, and fraternity are broad and idealistic. Critics say these words are not clearly defined, which may lead to different interpretations. No source of power. The preamble only explains the objectives and philosophy of the Constitution. It does not give any real power to the government or citizens. Added words by amendment. Some critics argue that adding words like socialist and secular through amendment changed the original spirit of the preamble adopted in 1950. Merely introductory in nature. According to critics, the preamble is only an introduction and has symbolic value rather than practical significance in daily governance. Does not specify methods to achieve its goals. Conclusion. Despite these criticisms, the preamble continues to hold great constitutional and moral importance. It may not be enforceable, but it remains the guiding philosophy and soul of the Indian Constitution. However, these criticisms do not reduce its constitutional importance. Conclusion. The preamble is the soul of the Constitution of India. It expresses the hopes and aspirations of the people and lays down the fundamental values of the Indian state. Though it is not enforceable, it plays a crucial role in guiding legislation, governance, and judicial interpretation. The preamble ensures that the Constitution remains committed to justice, liberty, equality, and fraternity, making it a living and dynamic document.